everyone. Thank you for joining part 2 of our broker roundtable meeting. Ken Moon will be discussing the changes to the California Residential Purchase Agreement. If you have any questions throughout the webinar, please feel free to type those into the questions box so I will be able to see them. And Ken, if you would like to start off.
Okay. Welcome everybody. As Victoria mentioned, this is phase 2 of the new RPA. We're going to keep this under an hour, so we're going to zip right through it. The agenda today is we're going to have some folks from Movement Mortgage talking with us, and Jeff Green, our illustrious broker from Northern California, going to be talking about part 2 of the residential purchase agreement, and then Q&A. And here's Jeff Green. Take it away, Jeff.
Man, I just want to pause for a moment and look at that picture. It's amazing. I mean, I'm not normally that blurry, but it's kind of a tough morning getting up today. But I'm excited to be talking to all of you agents, but I particularly want to direct my comments to the wonderful Northern California group and remind you that we're having a series of regional meetings with Allison James Estates and Homes Vice President Jessica Crumbaugh. So if you haven't had a chance to register, please do so. November 12th through 14th, we're going to be in 5 different locations in Northern California, and I will be posting, or there will be an email that will come through. One came through yesterday. There should be another one coming. There'll be many emails coming, so if you've already signed up, don't ask why. We just have to blast everybody till we get a good turnout. We have quite a few people registered already, but we'd like to see a really good turnout. Jessica is a very engaging and informative speaker. Plus, we're going to have a really good time and get to see each other, so it'll be a lot of fun. So I look forward to seeing you and look forward to the presentation today. Thank you very much to everyone.
Okay, great. Thanks, Jeff. And next we have what from our Allison James Strategic Partner Movement Mortgage, our Southern California mortgage advisor. A wonderful resource for everybody, and it's Shelley Hoyseth of Movement Mortgage. And take it away, Shelley.
Hi, Ken. Good morning, everyone in California. I just wanted to kind of touch base in keeping with the theme of contracts, talk a little bit about the section that refers to what buyer and seller are paying, and specifically talking about county and city transfer taxes and owner's title. Those are things that I think we kind of take for granted are typically paid by the seller, because I would say about 90% of the time that is the case, where the seller does pay for the city and county transfer taxes and also the owner's title policy. But occasionally, especially with short sales, bank-owned properties, and with new construction, the seller will not pay for these items, and that has been kind of a gotcha sometimes that has come up from time to time. So I just wanted to remind everyone to really be aware of that area. Be sure you do check those boxes, and to make the loan officer aware of how that is taking place as early on as possible. We do have to disclose on the good faith estimate and on the HUD as part of the buyer's cost those fees. And typically we'll show them as a credit just because they usually are paid by the seller. But the sooner that you know who is paying for those, if the buyer does have to pay for that, just wanted to remind you to keep your eye out for those when you have new construction and short sales, especially if you are in areas like San Francisco, Los Angeles, where the city tax is ridiculous. It could be thousands of dollars, and then the buyer is suddenly shocked and not happy, and then they're not happy with any of us. So that's my reminder, my mortgage minute of the day. If you have any questions, you can call, email me anytime about loan programs, guidelines, pre-approvals. I myself directly or one of my team members will reach out to your clients directly and answer any questions you have. Take it away, Ken Moon.
Great. Thanks very much, Shelley. Really encourage anybody. Shelley is so great, has helped some of our agents in Southern California so far, and that relationship's really growing, and it's really a big help to our agents closing deals. Well, here we are with the residential purchase agreement, phase 2. There are over 60 changes from the previous one. Major changes in the sequence of the agreement, and lots of new forms referenced. So if you didn't see the first part of this, the first half of this last month, please be sure and look at the information that's online. We'll be giving you a link to where you can get all this information online at the end of the presentation. Many old forms are gone. For example, the wood destroying pest addendum is a biggie, and well, that's fun. There we go. So here we are in title investing. As we go through this, I'll try to give you a little update on which parts of this are different. Many sections of this are pretty similar to what we've had in the past, and this is one of them. This section spells out in a little more detail what a preliminary report actually is. You'll notice when you look at the new contract instead of 8 pages is 10 pages. So they've expanded quite a few areas and added some things. So explains what a preliminary report is, and what they do and how they give it out. So it's pretty self-explanatory. Title is just pretty much similar to what we've had in the past. The area in red here, the manner of taking title, may have significant legal and tax consequences. That's always been in there. This is pretty much the same as it's been in the past. It just a good word to the wise for everybody is make sure you don't recommend how people take title. Don't put yourself in a position of being their attorney, because you can't be. So the homeowner's title policy, this is very similar to what it was before, except down in the middle here where it says if a homeowner's policy isn't available, that's something that's added. But not much of a big change with that. Time periods for contingencies and removal of contingencies. I get a lot of questions from people about, gee, we're past the contingency removal period. Does that mean we're going to lose our deposit and all this kind of thing? This last line here, that removal of contingencies or cancellation must be exercised in good faith and in writing. No contingencies removed until it's removed in writing. So even if it's 30 days into the transaction and the contingencies were supposed to be removed at the end of 10, if you have not removed them, or if you haven't waived this part of it, sometimes people will say they automatically expire. They'll put that in a counter. If you've got that kind of a situation, then they do expire. But in general, unless they've been removed in writing, you're still safe. And from the seller standpoint, be sure and get them removed when it's time to get them removed. If you want to protect your seller's interest, be sure and do that. The seller has so many days to get disclosures done, and if they haven't delivered them, the buyer can cancel, but they first have to deliver a notice to seller to perform. So that hasn't really changed. this also is very similar to what it's been in the past about disclosures. There's an obligation of the buyer to sign the disclosures when they get them. There's an obligation of the seller to get them to them. As everybody knows, the contract is an as-is contract, but we do allow the buyer to request the seller to make repairs. That's why we do the inspection. The seller has no obligation to agree to any of buyer's requests. And this is a new form. The request for repairs, of course, is being modified, but the new form RRRR is the response to the request for repair by the seller, and they're under no obligation to comply with this buyer's request. But then, of course, you can end up having a cancellation. So that's a little change right there. The removal of cancellation rights. This has not really changed. It says that we're supposed to deliver the removal of the contingencies or cancel the agreement. But if the seller hasn't provided any disclosures for which they're supposed to, then the buyer has 5 days after delivery to deliver to seller removal of the applicable contingency or cancellation. This says that even after the end of the contingency period, if the seller hasn't canceled, then the buyer can remove the remaining contingencies or cancel. So that goes back to what I was saying before. If you've got a 17-day contingency period, if you're in 25 days and nobody's forced you to remove contingencies and you still want to cancel, you can cancel. Once the buyer has removed all contingencies, the seller cannot cancel. Okay? Hopefully that makes sense to everybody. And all these paragraphs are really kind of either side of it written two different ways, but the seller's right to cancel if by the time specified in the agreement the buyer does not deliver to seller a removal of the contingency or cancel, then the seller can cancel. But first they have to deliver to the buyer a notice to buyer to perform, and that has to be done, they have to give them at least 2 days. So and if they do that, then the seller shall authorize a return of buyer's deposit except for fees incurred. That addition of except for fees incurred is new text in this version. And this this return of the buyer's deposit is also something that's a kind of a new concept that they've added in that we'll get to as we come along. But watch out for that, because it used to be that people had some leverage at the end of it if they canceled, but that's changed. The seller can cancel the agreement after they deliver the notice of buyer to perform. If the funds aren't good, if they haven't delivered the notice they need to deliver for FHA or VA, if they haven't delivered a letter, haven't delivered verification of funds, return the disclosures, and if there's an increased deposit, this is new, they have to sign a separate liquidated damages form, or provide evidence of authority to sign. This whole concept of representative capacity is a new wrinkle in the contract, and there's a new form for that, the representative capacity form. So That's for a lot of trusts and LLCs and different kinds of legal entities as sellers and buyers. If you're going to sign for one of those kinds of entities, you need to have this representative capacity form. We'll get to that. Notice to buyer to perform. It has to be in writing, it has to be signed by the applicable buyer or seller, it has to give the other party at least 2 days after delivery, whichever occurs last, to take the applicable action, and it may not be delivered any earlier than 2 days prior to the expiration of the time for the other party to remove contingency or cancel. What that means is if you're coming up on the 17th day of a contingency period and you want to make sure that they remove contingencies on time, on the 15th day you can deliver a notice to buyer to perform to remove contingencies, and they have to have it done on the 17th day or you can cancel without any further notice. And it works the same way the other way. Notice to the seller to perform. If they haven't provided the disclosures or if they haven't done something they need to do, the buyer can cancel. Okay. The effect of having removed the contingencies, this is pretty similar to what was in the contract before. It's just been rewritten a little bit, but very similar. If you remove the contingencies, the buyer is deemed to have completed all their investigations, approved everything, they've elected to proceed with the transaction, and they've assumed all liability responsibility for repairs, corrections, or anything else. Inability to obtain loans, anything, once they've removed all contingencies. The other item that is often a demand to close or demand for somebody to perform something is a demand to close escrow. And what this section says is that you have to, before you can cancel because they haven't closed on time, you have to give them a demand to close escrow. It's kind of like demand to perform, but you have to give them at least 3 days after delivery to close escrow. It may not be delivered any earlier than 3 days prior to the scheduled close of escrow. Okay. The effective cancellation on deposits, and this gets into a little bit of a new section. This language right here is very similar to what was in the old contract, but it adds in the part about fees and costs may be payable to service providers and vendors. But it says that the parties agree to sign mutual instructions to cancel the sale and release deposits. You know, what this section, this is a whole new section here. This says that the release of funds will require signed release instructions from the parties, judicial decision, or arbitration award. Okay. Now, what often happens is the parties disagree about who ought to get the money, and sometimes the buyer who has gone past, removed their contingencies and their deposits at risk, the buyer will try to hold up the party who wants to sell his property and try to negotiate a smaller portion of the deposit or whatever. But if he fails, if that buyer fails to execute instructions to cancel, the seller can make a written demand to the escrow holder for the deposit. And if the escrow holder then has to deliver a notice of the demand to the other party, and if within 10 days of that escrow holder notice the other party doesn't object, then the escrow holder can just pay out the money without getting the other party's signature. That is completely new. And it also has some protection in here that says if the escrow holder complies with the proceedings process, each party shall be deemed to have released escrow holder from any and all claims or liability related to the dispersal of the deposit. And then it also gives the escrow holder an out here that the escrow holder may, at its discretion, still require signatures from everybody, which I expect a lot of escrow companies will do that. But this is really new, gives the escrow holder an out, and they can make a notice and pay out the money if the other party doesn't object. And of course, if the other party does object, then they make themselves potentially liable for a lawsuit for unreasonably withholding the funds, because they can be subject to a civil penalty of up to $1,000 if no good faith dispute exists as to who's entitled to the deposited funds. So quite a significant change there in the information on deposits. Final verification of condition. This hasn't changed. It's not a contingency of the sale, but we do need to do the final verification, make sure that the property's been maintained and repairs have been completed and sellers complied with other obligations. Repairs. This really hasn't changed at all. This is pretty much the same as it's been in the past. Has to be done in a skillful manner. The seller does repairs. They have to prepare a written statement indicating what they did, etc. Prorations of property taxes. This is all pretty much the same as before. A little bit of a rewording of it, but pretty much the same as it's been. This has some this is not much different either. This is pretty much the same. The prorations of taxes and other items. Compensation. This new section. This is a new section called brokers, which isn't in the old agreement, and there's a lot of information in here that essentially is to protect the brokers and make sure they get paid. That means you, because you guys get what the broker gets. So seller or buyer, they agree to pay compensation to the broker, and it's payable on close of escrow, or even if escrow doesn't close as otherwise specified, potentially. It outlines what the broker's duties are, and this is all new. Does not decide what price the buyer or seller should accept, doesn't guarantee the condition, doesn't guarantee the performance, adequacy, or completeness of inspections or repairs, does not have an obligation to inspect common areas or areas off the side of the property. So these are all things that were not specified in the old contract that are in there for protections to the real estate agent. Not responsible for inspecting public records, permits, or identifying location of boundary lines. I think this is probably from that lawsuit that occurred up in the Salinas area. Colwell Banker Company got stuck with about $250,000 loss because of somebody didn't check to see if something was over an acre. But anyway, that's been added to the agreement. Not responsible for verifying. These are all things that are new. Not responsible for determining fair market value. Not give legal or tax advice. And this is the biggie, number 11 here, shall not be responsible for providing other advice or information that exceeds the knowledge, education, and experience required to perform real estate licensed activity. Buyer and seller agree to seek legal, tax, insurance, title, and other desired assistance from appropriate professionals. So that really hopefully takes us off the hook and also serves as a reminder to all of us that we, of course, don't want to give those kinds of advice to people because we're not qualified to do it. So it's a great idea, and we can just point them to this contract. This also is a new section, representative capacity, that we mentioned before. There's a new form, this representative capacity signature addendum. And what this says essentially is that if anybody is representing an entity like a trust or a corporation or an LLC or anything like that, that they need to fill out one of those forms, and that wherever their signature initials are in the agreement, it's going to be deemed to be the same as it is on the RCSA form. And it also says here that within 3 days after acceptance, they have to provide documentation to prove their authority. Okay. The joint escrow instructions, this is all pretty much the same as we've had in the past. The paragraph numbers have changed because things have really shifted around, and there's a section titled Real Estate Brokers that's a whole new section that they don't identify by paragraph number. They just call it the section titled Real Estate Brokers. So anyway, that's pretty much the way it was. Talks a little bit about separate compensation agreements, and this all is pretty much the same as it's been, except for some of the paragraph numbers. And this is also the same as it's been in the past. A little bit of a rewrite on this. It adds in that the escrow holder shall deliver to buyer a qualified substitute statement. I get quite a few questions on the checklist about the seller's affidavit, which is actually the FERPTA requirement, and that's what they're talking about here. The seller's FERPTA obligation, the buyer, if you represent the buyer on a transaction, you're obligated to withhold part of the proceeds and pay it to the state unless you get satisfactory proof that the seller is not subject to that withholding, and that's what the whole FERPTA thing is about. So that's why we have it on the checklist, and that's why we need to get either the seller's affidavit or the qualified substitute statement from escrow. So that's what that's about. Then this is more of the same stuff about the brokers, that we're just here to get money. We're not parties to the transaction, and that you can only change the compensation with written consent of the brokers, and everybody's releasing the escrow holder from any liability for paying that. This has not really changed much, just a little bit of a rewrite. And copies of any amendments will be delivered to escrow holder within 3 days after mutual execution. Then remedies for buyer's breach of contract. this says that if the parties, any clause has been added by the parties, and I should just reiterate a little bit one of the things we talked about in the first webinar on the contract. Any clause that you put, any text that you put in an addendum to the agreement becomes a clause, a section of the contract. It is part of the contract itself. So I really encourage everybody to be careful how you write things. Make sure it's clear. I see a lot of addendums that have a lot of acronyms and abbreviations for things. You really should spell things out in those addenda because they become part of the contract. But any clause that's been added, like in an addendum or in some other form that's been incorporated in the agreement, that specifies release or forfeiture of a deposit or making a deposit non-refundable because the buyer didn't complete the purchase, etc., any of those will be deemed invalid unless the clause independently satisfies the statutory liquidated damages requirement set forth in the Civil Code. So there are other sections that talk about that, but that's real important. That if you guys might agree, the seller might say, look, I want an extra $20,000 if they don't close on time, and the buyer might agree to it, but it's not valid if it doesn't satisfy the liquidated damages requirement. So we'll get into liquidated damages a little farther down. Right here. The if they fail to complete, if there's liquidated damages, it's if the property is a dwelling with no more than 4 units and the buyer intends to occupy it, then you cannot have liquidated damages more than 3% of the purchase price. That's it, period. Except as provided in paragraph 14G, that's another section. The release of funds will require mutual signed release instructions for both buyer and seller. The 14G is that thing about if there's no agreement, the escrow holder can release it if there's no objection. If there's an increased deposit, the buyer and seller have to sign a separate liquidated damages provision incorporating the increased deposit as liquidated damages, and that's CAR Form RID. That's a new form that that needs to be added. So that's one of the big changes.
Hey, Ken?
Yes, sir.
Ken?
Yeah.
Yeah, before you move on, I just wanted to jump in here real quick. You were mentioning being very careful about wording and how things are written. From time to time, I see a lot of duplicative language in addenda that are written. Things like buyer should conduct all inspections. I saw an SPQ this morning where I know that the client had to be coached by the agent to do this, but on every paragraph they wrote buyer to conduct all inspections, buyer to conduct all inspections, buyer to conduct all inspections. So duplicative language, it just kind of muddies up the paperwork. Things like on counters, all other terms to remain the same. Well, that's a given. So I think that your point is well taken. To be very careful what you write. Make sure you use economy of speech. The more ways you word it and reword it, it can enter and introduce some ambiguity to what's really being said. So look at it and make sure it's not something that can be interpreted multiple ways.
Yeah, exactly, exactly. And yeah, I can't think of an example, but I had one just recently where I understood what they meant, but what they said wasn't what they meant on the addendum. So yeah, you just have to be really careful. The mediation is really pretty similar to what we've had in the past. And we'll get into the exclusions. Arbitratees that we're going to do arbitration, and this defines all of it. The exclusions from arbitration and mediation are down below here. This is where you initial to agree to it. Judicial or non-judicial foreclosures, or judicial proceeding to enforce a deed of trust, mortgage or installment land sale contract, an unlawful detainer action, filing or enforcement of a mechanic's lien, and any matter that's within the jurisdiction of a probate, small claims, or bankruptcy court. So if the court takes over, then mediation doesn't happen. Those are exclusions. So the filing of a court action to notice, like a lease pendants or a filing of a mechanic's lien, those are not a waiver or a violation of mediation arbitration. In other words, you're saying, okay, look, I agree that I'm going to mediate and arbitrate, but I'm going to file this to make sure that I protect myself to give notice of a pending action, or file a mechanic's lien because I want to make sure I get paid. So that's not a waiver. And brokers are not obligated to mediate or arbitrate or participate in the mediation or arbitration unless they agree to do so in writing. And if the broker participates, they are not deemed a party to this agreement. I have appeared at mediation conferences on behalf with clients, but we're not obligated to do that. But oftentimes it's a good thing to do to just make sure your client understands you're backing them up, but we're not obligated to. And this is one more time where it says that the brokers are not guaranteeing the performance of vendors, whether we referred them or we didn't refer them or anything. Just restates that the buyer and seller are responsible for selecting their own providers. This is not changed. It's been the same for last form and this one. Attorney's fees, this is the same. Assignment, this is kind of new. This is says the buyer will not assign any interest in the agreement without first having obtained a separate written consent of seller. It won't be unreasonably withheld, but it does not relieve the buyer of their obligations. That sometimes an agent may sign as, say, John Doe purchasing something, and then assign it to the buyer that was using them as kind of a straw man in front. It doesn't relieve the person who signed that offer from their obligations under the agreement unless they can get it in writing from the seller that they're relieved of it. So that's a little thing to be careful of. If you are acting as doing something and then you're going to assign a contract, or if you're signing it personally and then assigning it to an LLC or something, you have to get the seller's agreement to get yourself off the hook. This is not changed. It's the same last contract in this. Terms and conditions of the offer. This is pretty much verbatim what it was in the previous contract. Time is of the essence. All pretty much the same. The definitions are all pretty much the same. Acceptance is a new one, I believe. Just means the time the offer or final offer is accepted in writing. This, by the way, makes it really important. I know a lot of times people will get things signed and they don't worry too much about the date. Really important to get people to put the date on things when they sign it, because a lot of things depend on the dates things were signed. So really important that we get those things done. Car form, all this stuff is pretty much the same as it was before. Get questions about days from time to time. It means calendar days, but if something's supposed to happen on a particular day, if your 17 days comes up on a Sunday or a Saturday or Labor Day, it can't happen on that day. So it's not required to happen until the next day, after the next day that's actually a day that's not a Saturday or a Sunday or a legal holiday. Days after.
Ken?
Yeah.
Are they defining legal holiday as a federal, or does that include state holidays?
It doesn't say.
Okay.
It doesn't say. Yeah, you mean like Columbus Day?
Yeah.
Yeah, no, I don't know. It doesn't say.
Okay. It's a car legal question, I guess.
Yeah, I expect. Days after, sometimes people get a little confused on how to count. If the date of acceptance, if somebody accepts it on the 15th and there's something supposed to happen 3 days after, it means you don't count the day it occurs. I'm sorry, you don't count the day that you're counting from. You count just the days after that. So you don't count the 15th. The 3 days after would be 16, 17, 18. So 18 would be the day. Days prior works the same way. People get a little confused on that. Delivery, there used to be a form on delivery of notices. It was an RDN form, which I thought was a really good form, but they've abolished that form. But this specifies what delivery is when it happens. That it's deemed to be received by the party when they receive it, or when their agent receives it. So if you as an agent receive something from somebody in the email, it's received by your buyer or seller, your client, that very same time, in terms of this agreement. Electronic copies just tells you what electronic signature and copy are, and you agree not to modify or alter. This is the same as it's been. Law is the same. All these things are the same as it's been. Expiration of the offer. This really hasn't changed except the addition of the information about representative capacity. This has been added on. So if one or more buyers are signing in a representative capacity, you have to check this box and then attach a representative capacity signature addendum. This is new. So if you do a lot of work with LLCs or trusts, make sure you get this form taken care of. Acceptance of the offer. This is new because there's a new thing on the counteroffer. There are seller's counteroffers and buyer's counteroffers now. The seller's counteroffer is SCO. And SMCO, seller's multiple counteroffer. The counteroffers are different than they used to be. It used to be you just checked who was making the counteroffer, and now it's a whole different form. So that's something you need to be aware of. Lots of new things. Also, there's this section down at the bottom here on additional signature addendum. That's also something that's been added to the agreement. The confirmation of acceptance, that hasn't changed really. And then the whole section on real estate brokers. The real estate brokers aren't parties to the agreement, and agency relationships are confirmed, and cooperating broker compensation, we're agreeing to how we're going to pay. If the listing and cooperating broker are not participants of the MLS, then we need a specified written agreement, CAR Form CBC. That's been around for a long time. And a declaration of license and tax can be used to document tax reporting. Everybody should be aware of that. If you have somebody that's making an offer from outside the jurisdiction, you need to make sure you get a CBC form done for compensation. And then this is just pretty much standard stuff that we've had all along about escrow holder, etc. And the rejection of the offer. Really good idea. I know a lot of people don't do this, but a really good idea to, on every offer, to put the date that it was presented to the seller. And if you're not gonna counter, get the seller to initial it and what date it was rejected. We get Jeff and I get an awful lot of noise from disgruntled buyers that they feel that their offers weren't presented properly or the seller never got to see it. If you've got this documented, you're golden. You just send them a copy of this and say, sorry, it was rejected, and it's not your fault, it's not a problem, but it really, really goes a long way to keeping you protected from some disgruntled buyer's agent or buyer accusing you of trying to steer a deal toward so you can double end it or something like that. It really goes a long way to protecting yourself. So it's really a good thing to do. For more information, this first line here, for additional resources, this on.car.org/RPA2014, I got this link from Barbara Gray, who was kind enough to let me know about it. And if you click on this link, it will take you to a page on car.org, if it will get there. And it has a link to a redlined copy of the new RPA, which we've had in the past, but it also gives you all these forms, all the new forms that are coming, all the draft copies of all the new forms, so you can look at them all here. Very, very helpful. And if you go up here, I don't know if you can see a final RPA draft, click here. Is that visible, Jeff? Hello, Jeff?
Yes, it is. Yes, it is.
Okay. Yeah, okay, great. If you can click on this, and then this has all the changes in a blue font for you. So all those things are great. And then if I can get back to my round table here. So anyway, that's a great link for everybody, and I would really recommend that you go there and look through that and satisfy yourself about it. Let me get back to this form. And of course, if you have any questions, you can call me or Jeff, or or for anybody in the Temecula area, call Joran or Lisa if you've got questions about any of these changes. These are all going to go into effect November 24th. So it's just right around the corner, not quite a month away. Just a word to the wise, everybody just do your best to be able to get this stuff put together. Does anybody have any questions? I don't know if Victoria's been receiving questions about any of these items.
Yes, Ken, we have a few questions here.
Okay.
Let's start off with one. I don't understand how to handle termite repairs without an RPA.
Without a WPA, maybe.
Yeah, I think it was supposed to be WPA. Mm-hmm.
Yeah, yeah. Well, what you have to do is you have to handle it just like a home inspection or any other inspection. And what you do is you check one of the items on the RPA, like where you would check for who pays for what. You check buyer or seller, whoever you deem that should pay for it, will pay for a wood-destroying pest inspection, and who's going to do it, and it says, and then your request for repairs, when you get that inspection, the request for repairs would include repairs for termite damage. So it's handled now, instead of a separate category of repairs, it's just like any other repair. It's handled just like that. So if you wanted a termite inspection, you ask for one. If you're going to pay for it, you say you're going to pay for it. If you're not going to pay for it, you say you're not. So you ask the seller to pay for it.
Okay.
Okay.
I have another one here. Is Section 21A only applicable if 21B is initialed?
21A, okay. Let me open up my friendly RPA here, and Section 21. Okay. Yeah, 21A and B are together. The initials go for both of those items. You're obligated to do mediation either way. The arbitration of disputes down here, I believe that is yeah. Actually, that's a really good question. I'm not positive of that, because I think the one down here, the initials for B only go for arbitration of disputes, not for mediation, because it doesn't say anything about whether it's initialed on that section. I know we're obligated to mediation whether we initial or not, but mediation isn't binding. The initials, the arbitration is binding. So I'll check on that and get that cleared up. Send everybody a note about that.
Okay.
You got any thoughts on that one, Jeff? Maybe you got maybe we lost
Jeff. Sorry, I was muted. No,
way.
I think as you covered that, we just I'm here. I'm sorry, I had an issue come up. I was not following that discussion there. I had something I had to jump on here, but I'm back.
Yeah,
with you.
no problem. Anyway, I'll let people know if that covers both items. I'm really not positive. I don't think it does, I think it just covers the paragraph that is initialed. I don't think it covers the, I think A is separate from B. In other words, I think you have to, I think 21A is valid whether you initial B or not, but I'll check to make sure.
Perfect.
Okay, anything else?
We do have a few. Regarding co-listing agent and co-selling agent, is it still necessary to generate an additional agent acknowledgement CAR form?
Yeah, I believe it is.
Okay.
Who's asking that question? Is that one of my agents? Because I've made a big push on AAAs and lately.
No, I don't believe it is.
Okay. Yeah. It's very critical to have authorization there, and actually, even with the changes, to have the buyer sign off on, or the seller sign off on it, or if you're sometimes you're a buyer's agent and you want to pull in another agent, you're going to go on vacation or something like that, you can amend the agreement using the AAA. At that point, you're going to need to get copies of it to all sides, but it could be a good tool for you to be able to have somebody cover for you and actually sign for you if your client agrees, and if you're in contract at that point, you need to get agreement from the other side.
Okay. Let me see what else we have here. Can you reiterate whether or not the new contract changes the agency addendum requirements? Do we still need one from buyer's agent to both buyer and seller and a dual agency addendum, or does this take the place of those?
Now, I believe we still need the same agency disclosures. I haven't seen anything changed on that. The agency portion of it, excuse me for scrolling through this so quickly, it does confirm who does what, but it doesn't define the responsibilities of the agent. The agency disclosure, the Form AD 1, 82, and 83, although 2 and 3 are generally combined, those specify, well, actually here, see, item A here, the parties each acknowledge receipt of disclosure AD, Form AD. So, yeah, we do have to do that AD form and get all parties to sign it.
Okay. Let's see, I have another one here. What if the buyer or seller is a licensed realtor? Since the broker section says we are not party to the contract, what do we do?
Well, the broker's not a party to the contract per se, but if the buyer is actually the broker, the same as the broker, then there'd be some disclosure there that they were a party to the contract. They'd have to disclose that. They're obligated to disclose that they're a licensee, and that would be part of the documentation.
Okay, let me see. We do have another one here. Ken, if you could go to page 8 of the contract. What happened if seller doesn't sign RPA page 8, item 21 and 22, because relocation is moving the seller? So let's see.
RPA page 8, 21, and 22. Oh, okay. Yeah. Where the buyers have signed but the sellers have not? Yeah, it actually specifies in here that if one party is signed and the other has not, then that has to be cleared up with a counteroffer. It's because you have to do something to get so that the two parties have come to some meeting of the minds with regard to those sections. So either the seller, if the seller refuses to sign that portion, then they need to counter it out and get the buyer to agree that they're not going to be initialing that section.
Perfect. Okay, and here, let me see. Since there is now an RCSA form, does that mean the trust offer form goes away?
I don't know if they've eliminated the trust offer form. There's a list of those forms on that page we referred to. Let me see if I can get back to that. I think I closed that screen, but let's see. Yeah, no, I'm sorry, I closed that page. Here we go. Yeah, I didn't see anything about that being sunsetted, that form, but I'll if there is still a form for a trust, yeah, it seems like it would make it redundant to have a representative capacity signature addendum and also have a trust. But they do have, they are revising, it looks like, the TA here, the form TA, which is a trust addendum. So I'm not sure of that. I would recommend, if you'll see once November 24 comes along, you'll see a change in your zip forms online. You'll see what the documents that are available. We always want to use the most current documents anyway, the most current zip forms and CAR forms. So if they're not providing a trust purchase agreement, then you would use a regular residential purchase agreement with the representative capacity form. Does that make sense?
Yeah. Okay, great. We have another question here regarding the disclosure of the buyer or seller being a licensed agent or broker and acting as a principal in the transaction. Is it okay to disclose this on page 2, item 6?
Yeah, wherever you want to do it. Page 2 is one for additional terms, I believe. Item 6, yeah, other terms. Yeah, that's fine. Right there, other terms. Or you could include it in an addendum, but yeah, that's fine right there.
Okay, let me...
Because hopefully everybody's aware that if we're going to be, if the disclosure is about an Allison James agent that's representing themselves in the sale or purchase of property, it has to be, in order to be covered under the E&O insurance, it has to be a 1-to-4 unit property, and then there's some other requirements in terms of making sure that you get inspection and home warranty and kinds of things that you need to do to qualify under our E&O policy. So that's another set of issues as well.
Yes.
But yeah, it would be good. This would be a fine place to put the disclosure of someone being a licensee.
Perfect. Okay, we had a few questions regarding the days, whether they were business days or calendar, but you did touch base on that.
Yeah, they're always calendar days, but the deadline date cannot be a Saturday, Sunday, or a holiday.
Mm-hmm. Okay, I think that is it for right now. With questions?
Okay. Okay, great. Well, I sure appreciate everybody coming. For more information, gave you those other links, but also there's spots for laws and new forms and general legal updates. We can send everybody a copy of this PowerPoint. This actually is a Macintosh format thing called Spotlight, I think, or something, presentation. The new forms go live. Actually, I had this as the 26th. They go live on the 24th. The day before that, I'm going on vacation, and it's not because I planned that, but it is kind of a coincidence. Jeff Green, the very knowledgeable.
Good job, Ken.
Yes, Jeff Green, the very knowledgeable broker extraordinaire from the north, will be in charge in handling all my activities, and I will be on a sailboat in the Virgin Islands without a phone, limited Wi-Fi, basking in the sun.
Yeah, and last time you went on vacation was the day they rolled out Skyslope.
Perfect timing, Ken.
Yeah, and we were on tour with Jessica, going to all the agents, so it was perfect. So
yeah, right.
I'm looking forward to it. Hey, great job, Ken. This was awesome. I'm sure everybody's giving you a round of applause from their remote location, but this was fantastic. Thank you so much.
Oh yeah. Well, thanks everybody, and honestly, this is an awful lot of material. So if anybody has any questions, please don't be reluctant to call me or Jeff about this, because we want to make sure everybody's on the same page and understanding these documents, and hopefully it'll be a very smooth transition. So keep watching your emails and look out for new events coming from Allison James. We've got all kinds of good stuff going on, and we appreciate your being with us, and hope to talk to you soon.
Great.
Anybody else have anything?
I think that's it.
All right, great. Thanks everybody. Bye-bye.
Thanks a lot, everyone.
Bye.
Bye-bye.